Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about bail and detention for longer than is legally possible. Cases that should have gone to the Supreme Court of Canada, but didn't. Under Canadian criminal law, individuals who are taken into custody cannot be held for more than 24 hours without having a bail hearing. Unfortunately, in Alberta, there were insufficient resources in the courts and with Crown prosecutors to permit bail hearings to be heard within 24 hours, and individuals were being detained for longer than they were supposed to be detained because the system simply couldn't accommodate them. As a result of this, a class action lawsuit was filed against the Alberta government, arguing that for all of the people who were detained longer than the 24 hours, there were violations of their rights to be free from arbitrary detention, their right to life, liberty, and security of the person, because the government failed to follow the law. The government applied to dismiss the lawsuit on the basis of the fact that it's not fair to sue the government on the basis of their decision about how to allocate resources. But that is the core of the issue. And while there are certain decisions about allocation of resources that governments make, governments cannot be insulated against lawsuits entirely because of how they choose to allocate resources, where those decisions have specific impacts on the charter-protected rights of individuals. And while case law has established that there are many circumstances in which governments can't be sued for exercising their discretion about how to spend government money, the Supreme Court of Canada should have recognized that this was an important issue that required them to define the borders of when a government could be sued for failing to allocate sufficient resources to an issue and when a government cannot be. And although the court certainly cannot direct government spending, putting government on notice that they may expose themselves to lawsuits if they don't spend appropriately on things that are significant, like the charter-protected rights of accused individuals who are presumed to be innocent at law, then they may be liable to being sued. This was an opportunity for the Supreme Court of Canada to really clarify the law in this area and also to empower citizens more to be able to question the actions of government, to be able to challenge government on their spending decisions where that affects them specifically. And unfortunately, the Supreme Court of Canada really left this as something that is and continues to be a muddy legal question in Canada. It would be important for the Supreme Court of Canada to hear a case like this in the future to decide these issues, to allow the public to be better informed and better empowered where decisions made by government about funding affect their rights. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazenable Creative for putting together these videos. Please like, subscribe, and share with your friends.